All rise. Veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Good morning, everybody. Court officer, please call the case.
Thank you, Mr. President, Your Honors. The situation in the Democratic Republic of the Congo in the case of the prosecutor versus Bosco Ntaganda. Case reference ICC 0104-0206. For the record, we are in open session.
Thank you, court officer. First of all, I would like to welcome back the parties, the participants, and Mr. Ntaganda, the accused. I also welcome those who are watching this hearing from the public gallery or via the internet. Before I go into the purpose of this hearing, please state the appearances for the record and the public, and we will start with prosecution.
Thank you, Mr. President. Mr. President, honorable judges, the Office of the Prosecutor is represented by Nicole Sampson, senior trial lawyer, Julieta Solano, trial lawyer, Diane Luping, trial lawyer, Eric Iverson, trial lawyer, Marion Rabanit, associate trial lawyer, Hens van der Verf, associate trial lawyer, Christy Sim, assistant trial lawyer, Paolo Sachi, assistant legal officer, Claudine Umurungi, assistant legal officer, Selam Yirgu, case manager, and myself, Fatou Bensouda, prosecutor. Thank you, Mr. President.
Thank you, Ms. Bensouda. Now, defense, please.
Bonjour, Monsieur le Président, bonjour, honorable juge, et bonjour à toutes les personnes présentes dans la salle d'audience, représentant Bosco Ntaganda, qui est présent avec nous ce matin, Madame Camille Divet, Madame Raïja Mouslimani, Monsieur Benjamin Naudet, Madame Daria Machetti, Madame Sandrine de Sénat, Madame Margot Portier, Madame Chloé Grandon, Maître Didas Nirinkwaya, Maître Christopher Gosnell et moi-même, Stéphane Bourgon. Merci, Monsieur le Président.
Merci beaucoup, Monsieur Bourgon. Now, legal representatives for victims, please.
Merci, Monsieur le Président. Les anciens enfants soldats sont représentés par Alejandro Kiss, par Anna Bonini et par moi-même, Sarah Pellet, conseil au bureau du Conseil public pour les victimes.
Bonjour Monsieur le Président, bonjour Madame, Monsieur le Juge. Les victimes des attaques sont représentées par Anne Grabowski, juriste associée, Chérine Luzeizou, conseil sur le terrain, et moi-même, Dimitri Souproun, conseil au bureau du Conseil public pour les victimes.
Thank you, Ms. Pellet. Thank you, Mr. Souproun. And registry, please.
Thank you, Mr. President. Your Honours, the registry is represented by Jamila Zubir, Associate Legal Officer, and myself, Peter Lewis, the Registrar.
Thank you, Mr. Lewis. To make appearances complete, the chamber is composed of Judge Kuniko Ozaki on my right, Judge Chung on my left, and myself, Judge Robert Fremr. And the Chamber is today assisted by our legal officers. From the left, Ms. Nicole Fitzsimmons, then Ms. Esther Sabel, Ms. Marianne Sarako, Mr. Rohir Bartels, Ms. Raluca Rakashan, and Ms. Ala Ershova. Today, the Chamber renders its judgment pursuant to Article 74 of the Rome Statute in the case of the prosecutor versus Bosco Ntaganda. The judgment consists of 539 pages and 3 annexes. I will now read out a summary of the judgment which serves to convey those findings made in the judgment that to be considered most relevant to the accused and the public. The full judgment will be made available as soon as this hearing has concluded, and it's a fully public document. I will start with a brief procedural overview. An investigation into the situation in the Democratic Republic of the Congo, which I will refer to as the DRC, was opened in June 2004, following a self-referral by the DRC. On 22nd August 2006, an arrest warrant was issued for Mr. Ntaganda, followed by a second arrest warrant on 13 July 2012. After Mr. Ntaganda voluntarily surrendered to the court on 22nd March 2013, and through the cooperation of the United States of America, whose embassy in Kigali he had entered, Mr. Ntaganda was transferred to the seat of the court. A confirmation hearing took place from 10th to 14 February 2014, and on 9th June 2014, Pretrial Chamber 2 confirmed most of the charges the prosecution had brought against Mr. Ntaganda. After the confirmation of the charges, the case was referred to the President Chamber. Before the start of the trial phase, Mr. Ntaganda changed his defense team, following which additional time was granted to his new defense team to familiarize itself with the case. On 2nd September 2015, the trial proceedings commenced when the charges were read out to the accused and the parties and participants made their opening statements. Over the course of 248 days of hearing, the Chamber heard 102 witnesses called by the prosecution, the defense, and on behalf of the victims. 1,791 items were admitted into evidence, and 2,129 victims have been authorized to participate in this trial, and in addition to several victims testifying as witnesses before the Chamber. 5 further victims presented their views and concerns in person. The Chamber issued 347 written decisions and 257 oral decisions during the trial phase. After the presentation of the evidence, the Chamber received written closing submissions from the parties and the legal representatives of victims of more than 1,400 pages in total. At a hearing held from 28 to 30 August 2018, the parties and participants made their closing statements, after which the Chamber deliberated to come to the present judgment. I will now turn to the confirmed charges. This case is concerned with alleged conduct by Mr. Bosco Ntaganda as a member of the Union des Patriotes Congolais, which I will refer to as the UPC, and its military wing, the Forces Patriotiques pour la Libération du Congo, which I will refer to as FPLC. This conduct relates to events that took place in Ituri district of the DRC from on or about 6 August 2002 to on or about 31st December 2003. In addition to alleged conduct in relation to conscription and enlistment of children under age of 15 into the UPC FPLC and their use in hostilities, which was alleged to have occurred throughout the entire temporal scope of the charges against Mr. Ntaganda concern a series of assaults against towns and villages in 2 collectivités during 2 specific time periods. The assaults against towns and villages of the Banyali Kilo collectivité are alleged to have taken place between, on or around 20th November 2002 and on or about 6 December 2002. The alleged assaults in the Valendu Jatsi collectivité occurred between on or about 12th February 2003 on or about 27th February 2003. Mr. Ntaganda is charged with responsibility under various modes of liability for 18 counts, including 5 counts of crimes against humanity and 13 counts of war crimes, namely counts 1 and 2, murder and attempted murder as a crime against humanity and as a war crime, count 3, intentionally attacking civilians as a war crime, counts 4, 5 and 6, rape as a crime against humanity and as a war crime, count 7, 8 and 9, sexual slavery as a crime against humanity and as a war crime, count 10, persecution as a crime against humanity, count 11, pillage as a war crime, count 12, forcible transfer of population as a crime against humanity, count 13, ordering the displacement of the civilian population as a war crime, counts 14, 15 and 16, conscription, enlistment, and use to participate in active hostilities of children under the age of 15 years as a war crime, count 17, attacking protected objects as a war crime, and count 18, destroying the enemy's property as a war crime. Now, Article 74, paragraph 2 of the Rome Statute of the International Criminal Court, which I will refer to as the statute, requires the chamber to stay within the bounds of confirmed charges. These boundaries are defined by the confirmation decision, but this does not exclude that further details about the charges as confirmed by the pretrial chamber may also be contained in other auxiliary documents. Regulation 52B of the regulations of the court sets out that the charges must contain a statement of the facts, including the time and place of the alleged crimes, which provides a sufficient legal and factual basis to bring the person to trial. The chamber has assessed on a case-by-case basis whether the charges are sufficiently specific to comply with that regulation, taking into account, inter alia, the nature of the crime charged and the circumstances of the case. Pursuant to Article 66 of the statute, the accused shall be presumed innocent until proven guilty, and it is for the prosecution to demonstrate the guilt of the accused. For a conviction, each element of the particular offense charged must be established beyond reasonable doubt. Therefore, all the chamber's factual findings that underlie its legal findings made in the judgment are established beyond reasonable doubt. When determining whether the applicable evidentiary threshold has been met, the Chamber has carried out a holistic evaluation and weighed all the evidence taken together. In case the evidence would allow for more than one possible finding, the Chamber has made the finding most beneficial to the accused. The prosecution presented various types of evidence to incriminate Mr. Ntaganda. Many of the prosecution witnesses were granted protective measures pursuant to the Chamber's duty to ensure the security, privacy, and psychological well-being of witnesses as enshrined in Article 68 of the Statute and Rule 87 of the Rules of Procedure and Evidence. Because many witnesses were granted in court protective measures, much of the trial proceedings took place in private session and could therefore not be followed by the public, either in the public gallery or online. Therefore, the Chamber has ensured that the judgment is a fully public document, so all the relevant aspects of the case are available for those who are interested. The prosecution's witnesses included so-called insider witnesses, which means former members of the UPC FPLC, both soldiers and persons who had a non-military role. Some of these soldiers testified that they were below 15 at the relevant time. In addition to the insider witnesses, the Chamber heard crime-based witnesses who testified what had happened to them or members of their family or communities during the assaults on the town and villages. Several of these witnesses are also participating victims. The Chamber identified, based on the parties' and participants' submissions or its own observations, a number of issues requiring the credibility of certain witnesses to be discussed on an individual basis. In assessing the credibility of witnesses, the Chamber considered the individual circumstances of each witness, including his or her relationship to the accused, age, any involvement in the events under consideration, any possible bias towards or against the accused, or any motives for telling the truth or providing false testimony. The Chamber has also taken into account that the charges relate to events that occurred a relatively long time ago, in 2002 and 2003. Some witnesses were very young at the time of the events and or suffered trauma, and therefore may have had particular difficulties in providing a fully consistent, complete, and logical account. The Chamber has relied on the evidence of witnesses in relation to whose credibility the Chamber has some reservations, but only to the extent that it was corroborated by other reliable evidence. However, the credibility of certain witnesses was so impugned that they could not be relied upon, even if parts of their testimony were corroborated by other evidence. Certain parts of the testimony of witnesses has not been relied upon, including for a few witnesses who were alleged to be below 15 years old when they were recruited into the UPC FPLC regarding their age. The defense called 19 witnesses, a number of whom were also granted protective measures. One of defense witnesses was the accused himself, who testified for 30 days. Mr. Ntaganda's testimony was detailed and comprehensive and touched on all matters relevant to this case. As it can be seen throughout this judgment, the Chamber has always considered his testimony and, where appropriate, relied on it for findings of fact. In doing so, the Chamber has assessed the probative value of Mr. Ntaganda's evidence in the context of the totality of the evidence. In instances where the evidence provided by Mr. Ntaganda is contradicted by other evidence, the Chamber has also considered on case-by-case basis and where appropriate the possibility of Mr. Ntaganda's incentive to provide exculpatory evidence in the context of all the relevant evidence. In relation to important aspects of the charges, the Chamber has found that Mr. Ntaganda's evidence was rebutted other credible and reliable evidence. Various expert witnesses testified also before the Chamber, ranging from psychologists who testified about the impact of trauma on the memory of witnesses, to forensic scientists who analyzed bone and tooth fragments that had been collected from graves in the relevant area. Where relevant, the Chamber has relied on the evidence provided by these experts, albeit mostly as corroboration or as relevant context. The Chamber also received a large number of reports drafted by international or non-governmental organizations. The drafters of some of these reports came to testify before the Chamber. The Chamber has been careful in its assessment of these reports, mindful of the various challenges brought by the defense and the fact that the information on which these reports are based was not collected for the purposes of a criminal investigation and lacked certain safeguards. The Chamber has given more weight to the daily reports by United Nations peacekeeping mission MONUC, which were made contemporaneously with the events that took place during the charged period. I will now turn to the Chamber's main findings. This case of the prosecutor versus Bosco Ntaganda concerns violence in Ituri, which is a district of Orientale province in the northeast of the DRC, bordering Uganda, with a population estimated to range from 3.5 to 5.5 million people. The capital of Ituri is Bunia. Ituri region is fertile and rich in natural resources, which many actors inside and outside the DRC have sought to exploit throughout the years. The DRC has many different ethnic groups within its borders. In Ituri alone, there are approximately 18 different ethnic groups, including the Lendu, the Ngiti, and the Hema, and its subgroup, the Gegere or Hema North. The UPC, the group that Mr. Ntaganda was a member of, was formalized in September 2002, but existed as a political entity before that time. The group's activities were initially limited because some of its key leaders were still members of other movements, most notably the RCD-KML. Following a split from the RCD-KML in April 2002, the group became active under the name FRP. Thomas Lubanga, who would become the president of the UPC, was one of the FRP leaders. The leaders of the FRP became the political leaders of the UPC FPLC upon its formal creation in September 2002. At the end of 1999 and beginning of 2000, Mr. Ntaganda founded an armed group called the Chui Mobile Force, mostly consisting of dissidents of the military wing of the RCD-KML, called the APC. Besides Mr. Ntaganda, who was the group's leader, the Chui Mobile Force included later members of the FPLC, which became the military wing of the UPC, such as Floribert Kisembo and Duru Chaligonza. The members of the Chui Mobile Force were mainly of Hema and Tutsi ethnicity. They had left the APC because they claimed that this armed group sided with the Lendu and discriminated against the Hema. Around May 2002, the FPLC, the emerging military wing of the UPC, began to actively recruit individuals and train recruits at a training facility in Mandro. In July 2002, it obtained enough weapons which were transported by airplanes from Rwanda to arm all of the 1,800 to 2,000 recruits present at the time at Mandro. In early September 2002, UPC President Thomas Lubanga formally established the FPLC as the armed wing of the UPC. Lubanga himself was the FPLC's commander-in-chief. He appointed Floribert Kisembo to the position of Chief of General Staff and Mr. Ntaganda to the position immediately below this, the one of Deputy Chief of Staff in charge of operations and organization. The accused held this position until 8 December 2003 when Thomas Lubanga removed Kisembo as Chief of Staff and appointed Mr. Ntaganda to that post. The FPLC organizational structure was similar to that of conventional army, had a geographical division, and was subdivided into brigades, battalions, as well as smaller units. It used various communication systems, and orders given via the radio were noted down in logbooks. At the training centers, UPC FPLC recruits were instructed in the use of both light and heavy weapons. With regards to heavy weapons, recruits and soldiers of the UPC FPLC also received training in Rwanda. At the end of their training, recruits were provided with a personal weapon. During the relevant period, the UPC FPLC was involved in fighting with several armed actors, which, like the UPC FPLC, were sufficiently organized to be considered organized armed groups. The time between August 2002 to the summer of 2003 included periods of intense fighting, and even the calmer periods did not see a lasting absence of armed clashes, although Ugandan armed forces were present on the territory of the DRC and were to some extent involved in the fighting, and Rwanda provided certain support to the UPC FPLC at various times. The Chamber has considered that the involvement of other states did not amount to overall control and thus did not result in a classification of the conflict as being international in nature. It concluded that the UPC FPLC, throughout the temporal scope of the charges, was at all times involved in at least one non-international armed conflict with an opposing party. In relation to the contextual elements of crimes against humanity, the Chamber found that UPC FPLC's conduct against the civilian population was not the result of an uncoordinated and spontaneous decision of individual soldiers on the ground. It was the intended outcome of a preconceived strategy, as part of which the Lendu population was specifically targeted. The crimes committed against civilians took place pursuant to policy of the UPC FPLC to attack and chase away Lendu civilians, as well as those who were perceived as non-Iturians. The Chamber found that Mr. Ntaganda and other military leaders of the UPC FPLC, including Thomas Lubanga and Floribert Kisembo, worked together and agreed on the common plan to drive out all Lendu from the localities targeted during the course of their military campaign against the RCD-KML. Mr. Ntaganda and his co-perpetrators wanted to destroy and disintegrate the Lendu community and ensure that the Lendu could not return to the villages they were attacked. This involved the targeting of civilian individuals by way of acts of killing and raping, as well as the targeting of the public and private properties through acts of appropriation and destruction. As a result of the way the UPC FPLC was organized and the position of the co-perpetrators within the organization, the Chamber considers that the conduct of individuals who committed the crimes on the ground, namely UPC FPLC soldiers, and occasions of Hamas civilians assisting the UPC FPLC, must be attributed to the co-perpetrators as if it were their own acts. In relation to Mr. Ntaganda's conduct, as the Chamber noted above, he fulfilled a very important military function in the UPC FPLC. He was one of the key leaders. The Chamber has found his role to have been determinative in the UPC FPLC ability to set up a strong armed group that was capable of driving the Lendu population from certain areas. Mr. Ntaganda, who had obtained extensive experience in military affairs in the years prior to the UPC FPLC, was the one who devised the tactic that allowed the UPC FPLC to successfully take over the important village of Mongwalu after the UPC FPLC had previously failed to defeat the Lendu fighters at this location. This shows his importance for the organization. Mr. Ntaganda rallied the troops prior to battle, and he gave direct orders to the troops during part of the operations and debriefed them afterwards. In addition to these direct orders to target and kill enemy, including civilians, Mr. Ntaganda endorsed criminal conduct of his soldiers by way of his own conduct. Moreover, with his own actions, he showed his troops how the orders were to be implemented with regard to the treatment of Lendu civilians. Mr. Ntaganda's skills were held in high regard and relied upon within the UPC FPLC ranks, including for the planning and organization of its military operations. The UPC FPLC military campaign, which followed the UPC FPLC's successful takeover of Bunia, was largely dependent upon Mr. Ntaganda's personal involvement and commitment as one of the group's highest and most experienced and respected military figures. I will now turn to conduct against children under the age of 15 who were part of or associated with the UPC FPLC. As of June 2002, Mr. Ntaganda was involved in large-scale recruitment drives that were conducted by the UPC FPLC. On at least 3 occasions, he made calls for young people to join the UPC FPLC ranks and follow military training, and also stated that parents and families should provide their children to the group. Between August 2002 and June 2003, the UPC FPLC recruited, trained, and deployed children under the age of 15. The soldiers of the UPC FPLC were treated the same. Those under 15 were threatened, punished, and suffered physical violence, as were other recruits and soldiers. They wore uniforms or part of uniforms that were often too large for them and had weapons such as 47th. They took part in combat operations and were used as bodyguards or personal escorts by the commanders, including of Mr. Ntaganda. It was common practice for female members of the UPC FPLC to be raped and be subjected to other forms of sexual violence during their service. The chamber found that this included at least 3 girls under the age of 15 who each were repeatedly raped. I now turn to the UPC FPLC conduct during assaults on villages and towns from August 2002 to May 2003. On 9th August 2002, the emerging UPC FPLC, together with the UPDF, launched an assault on the city of Bunia, causing Governor Lompondo to flee with a group of APC soldiers. After having taken control of Bunia and the roads leading up to it, in the next months the UPC FPLC attacked the villages Songolo, Zumbe and Komanda. Killing and looting took place during these assaults and their aftermath. This conduct falls outside the charges that are brought in relation to the 2 military operations against towns and villages of the Banyale Kilo collectivité in November 2002 and early December 2002, and the one against the Walendu Jatsi collectivité in February 2003. However, the Chamber's findings on these assaults are important for the context of the UPC FPLC actions. Now, in turning to the Banyale Kilo collectivité, before the UPC FPLC attacked, the APC and Lendu fighters controlled Mongwalu and Sayo. The headquarters of the Lendu fighters was in Sayo. Mongwalu also was the seat of the Kilomoto Gold Mining Company. Around 9th November 2002, the UPC FPLC unsuccessfully tried to take over Mongwalu. Afterwards, following a plan by Mr. Ntaganda to attack from 2 sides, on or about 20th November 2002, the UPC FPLC launched an assault on Mongwalu using soldiers, including children under the age of 15, on the grounds with AK-47s, supported by heavy weapons. After it took over Mongwalu, the UPC FPLC also captured Sayo and Nzebi. In February 2003, the UPC FPLC launched a coordinated series of assaults at several villages in the Walendu Jatsi collectivité and took control of the villages of Lipre, Tsili, Kobu, Bambu, Buli, Gola, Jichu and Nyagarai, as well as some surrounding places. In May 2003, following the withdrawal of the UPDF from the city, the UPC FPLC engaged in fighting in Bunia, in which children under the age of 15 also took part. After a village or town was taken over, the UPC FPLC soldiers conducted what has been referred to by witnesses as ratissage operations. During the ratissage operations in Mongwalu and Sayo, house-to-house searches were carried out by the UPC FPLC, during which persons were abducted, intimidated, and on several occasions killed. UPC FPLC soldiers looted a variety of items such as household items, mattresses, clothing, and removed the roofs of some houses. There is no indication that these items served as a military purpose, and they were apparently used for personal use. As part of the assaults, and especially once the relevant village or town was taken over, UPC FPLC soldiers destroyed houses. For example, in Sayo, Lipre, Tsili, and Kobo, houses were burned down, specifically those with thatched roofs. During the attacks, heavy weapons were used to fire at houses. Although it was left standing, the UPC FPLC also fired at the health center in Sayo. Some of the women captured by the UPC FPLC soldiers were raped by them. Some of them were even killed, either when they attempted to resist the rapes or after they were raped. In the aftermath of the assault on Kilo, the UPC FPLC went after the Lendu in the village, searching their homes and killing some of them. The bodies of those killed were thrown into graves, some of which had been dug by those whose bodies were thrown in it afterwards. The killing was not always successful. A Lendu woman who testified before the chamber as a witness, for example, was held in a pit in the ground in Kilo after she was captured while fetching water. The next day, a UPC FPLC soldier slit her throat and she was left there, yet survived on that occasion. In a UPC FPLC camp set up after the takeover of Mongwalu, at a place referred to as appartement, abducted persons were held and questioned. The majority of the Lendu taken there were killed, while members of other ethnic groups were released. At this location, Mr. Ntaganda himself shot and killed Abe Bwanalonga, a man of an advanced age serving as a Catholic priest at the Mongwalu parish. UPC FPLC commanders, including Mr. Ntaganda, ordered their troops to engage in conduct that resulted in the displacement of a significant part of the civilian population. The population was shot at while trying to flee. During the assault on Sayo, for example, Mr. Ntaganda ordered a soldier operating the artillery to fire at people wearing civilian clothing, making their way up a hill, away from the village, not involved in any active hostilities. As the UPC FPLC assault on Mongwalu in November 2002 unfolded, many of those present in the town fled the town, going to the bush and to other places. Later, the civilian population of Lipri, Tsili, Kobu, and Bambu similarly fled to the bush. These orders to chase out the civilians did not aim to ensure the safety of the civilian population and were not justified by military necessity. While in the bush, those who had fled lived in difficult conditions with limited access to food, medication, and shelter. The Lendu could not return to their houses during the time the UPC FPLC controlled the villages concerned. It is worth specifically mentioning the massacre that took place in the village of Kobu. Following the assaults on Kobu and surrounding villages, UPC FPLC soldiers under the command of Salumu Mulenda around 25th and 26th February 2003 brought groups of captured persons to buildings in Kobu, one of which was referred to by witnesses as the Paradiso building. Many of the captured persons, women as well as some men, were raped by members of the UPC FPLC, including by Commander Mulenda. Shortly thereafter, UPC FPLC soldiers killed at least 49 captured persons at or close by a banana field behind the Paradiso building. They used sticks and batons as well as knives and machetes. The bodies of those killed, men, women and children and babies, were found in the banana field over the next days. Some bodies were found naked, some had their hands tied up, and some had their heads crushed. Several bodies were disemboweled or otherwise mutilated. I will now move to the Chamber's finding of Mr. Ntaganda's responsibility for the conduct that I have just mentioned. In relation to the Chamber's findings on Mr. Ntaganda's guilt, 3 issues must be emphasized. First, the Chamber has found that in relation to each of the 18 counts, a number or at least part of the charges were proven beyond reasonable doubt, and it will therefore enter convictions for the related crimes. However, the Chamber has not been able to make findings on a number of alleged incidents. Importantly, even though the prosecution initially alleged crimes to have been committed in a number of villages, and the pre-trial chamber confirmed charges in this regard, the prosecution did not lead any evidence with regards to some villages and did not maintain the associated allegations in its closing brief. This concerns the locations referred to as Goy, Langa, Minjo, and Wada. For some other locations which were referred to in the prosecution's closing brief, there was insufficient reliable evidence presented for Chamber to make any findings. This concerns Pluto, Avetso, Dhekpa, Thali, Mbijo, and Pili. With regards to Juba, Kato, and Diallo, the Chamber found only that the population fled, although the various crimes were charged. In relation to the UPC FPLC assault on Bunia in March 2003, the evidence did not show any crimes being committed by the UPC FPLC. Second, as I mentioned earlier when discussing the Chamber's assessment of witness credibility, the Chamber has found that it was not proven beyond reasonable doubt that some of the members of the UPC FPLC, who according to the prosecution were younger than 15 at the relevant time, were indeed below this age. For those specific allegations, no findings have therefore been made in relation to the charges concerning children under the age of 15 incorporated into the UPC FPLC. Then, third, as regards the legal findings, the Chamber has found that certain established facts cannot be legally characterized as crimes under the statute. Consequently, Mr. Ntaganda is not considered responsible for the allegations related to the aforementioned 3 points. Accordingly, Mr. Ntaganda is only found guilty for those facts established beyond reasonable doubt by this Chamber above. The Chamber has found that Mr. Ntaganda bears individual criminal responsibility under Article 25, paragraph 3a of the statute. This mode of criminal responsibility means that a person is criminally responsible if that person commits a crime within the jurisdiction of the court, either as an individual or jointly with another or through another person, regardless of whether that other person is criminally responsible. The Chamber has considered that Mr. Ntaganda was a direct perpetrator pursuant to Article 25 sub 3a for parts of the charges, for 3 of the crimes, and was an indirect co-perpetrator under the same provision for the other parts of these 3 crimes. For the other crimes, he was found an indirect co-perpetrator. Also, the Chamber considers that a person's conduct can satisfy the elements of more than one mode of liability, having found Mr. Ntaganda's principal liability to have been established for each of the counts charged. It does not consider it appropriate nor necessary to make any further findings on the other confirmed modes of liability. Having applied the legal elements of the alleged crimes to its factual findings, the Chamber concludes that Mr. Ntaganda bears individual criminal responsibility for the following crimes. Murder as a crime against humanity under Article 7, Sub 1a of the Statute, and as a war crime under Article 8, Sub 2c, Roman 1, as a direct perpetrator under Article 25, Sub 3a of Abe Bwanalonga in Mongwalu during the first operation, and murder and attempted murder as a crime against humanity under Article 7, Sub 1a, and as a war crime under Article 8, Sub 2c, Roman 1, as an indirect co-perpetrator under Articles 25, Sub 3a and 25, Sub 3f, in relation to the following killings and attempted killings committed by UPC FPLC soldiers, and in relation to the killing of people in Mongwalu during ratissage operations, also by Hema civilians. It includes the killing of a woman in front of the health center in Sayo in the context of the first operation, the killing of people in Mongwalu and Sayo during ratissage operations, and persons killed at the appartement camp following interrogation in the context of the first operation, the killing of 2 Lendo persons in Nzebe pursuant to Mr. Ntaganda's order in the context of the first operation, the killing of Lendu person and Giti man and a pregnant Lendu woman who had been detained in a pit, and of a Nyale man in Kilo in the context of the first operation, the killing of 2 fleeing children in Kobu during the assault and the killing of people during the ratissage operation that followed in the context of the second operation, the killing of 9 hospital patients in Bamboo, and the attempted killing of a 10th in the context of the second operation, the killing of a woman while she tried to defend herself against rape, and of another woman in Sanje in the context of the second operation, the killing of at least 49 persons in a banana field near the Paradiso building in Kobu in the context of the second operation, the killings of some men who were raped by the UPC FPLC soldiers in the context of the second operation, and finally the attempted killing of 4 persons who acted as witnesses before this chamber in the context of the first and second operation. He is also criminally responsible for intentional directing attacks against civilians as a war crime under Article 8, Sub 2e, Roman 1 of the Statute, and indirect co-perpetrator under Article 25, Sub 3a in Mongwalu and Sayo in the context of the first operation, and in Bamboo, Jichu, and Buli in the context of the second operation. Then, responsible for rape as a crime against humanity under Article 7, Sub 1g, and as a war crime under Article 8, Sub 2e, Roman 6, as an indirect co-perpetrator under Article 25, Sub 3a of women and girls during and in the immediate aftermath of the UPC FPLC assault on Mongwalu, of girls in Kilo in the context of the first operation, of detained women and men in Kobu, women in Sanji, and of a woman who testified as a witness in Buli in the context of the second operation. then he is responsible for sexual slavery as a crime against humanity under Article 7 sub 1G and as a war crime under Article 8 sub 2E Roman 6 as an indirect co-perpetrator under Article 25 sub 3A of a woman and an 11-year-old girl in Kobu and Buli in the context of the second operation. Further, for a rape as a war crime under Article 8 sub 2E Roman 6 as an indirect co-perpetrator under Article 25 sub 3A of an approximately 9-year-old girl at Camp Lingo, and rape and sexual slavery of child soldiers as war crimes under Article 8 sub 2E Roman 6 as an indirect co-perpetrator under Article 25 sub 3A in relation to the two girls under 15 years of age, one at Kambule and one assigned to Floribert Kisembo's escort. Then, for prosecution as a crime against humanity under Article 7 sub 1H as a direct perpetrator under Article 25 sub 3A of a priest in Mongwalu in the context of the first operation and as an indirect co-perpetrator under Article 25 sub 3A in Mongwalu, Nzebi, Sayo and Kilo in the context of the first operation and in Nyangarai, Lipri, Tsili, Kobu, Bambu, Sanji, Gola, Jichu and Buli in the context of the second operation. Then he is responsible for pillage as a war crime under Article 8 sub 2E Roman 5 as an indirect co-perpetrator under Article 25 sub 3A in relation to the looting of items in Mongwalu and Sayo by UPC FPLC soldiers, and in the case of Mongwalu also by Hema civilians in the context of the first operation, and in Kobu, Lipri, Bambu and Jichu by UPC FPLC soldiers in the context of the second operation. Further, for forcible transfer and deportation as a crime against humanity under Article 7 sub 1D and ordering the displacement of the civilian population as a war crime under Article 8 sub 2E Roman 8 as indirect co-perpetrator under Article 25 sub 3A in Mongwalu in the context of the first operation and in Lipri, Tsili, Kobu and Bambu in the context of the second operation. Then, for conscripting and enlisting children under the age of 15 years into an armed group between or about 6 August 2002 and 31st December 2003, and using them to participate actively in hostilities between, on, or about 6 August 2002 and on or about 30th May 2003, with respect to the participation of children under the age of 15 in the first operation and in the UPC FPLC assault on Bunia in May 2003, the use of children under the age of 15 as bodyguards for UPC FPLC soldiers and commanders, including for Mr. Ntaganda himself, and for the UPC President Thomas Lubanga, and the use of children under the age of 15 to gather information about the opposing forces and MONUC personnel as war crimes under Article 8 sub 2E Roman 7 and indirect co-perpetrator under Article 25 3A. Further, for intentionally directing attacks against protected objects as a war crime under Article 8 sub 2E Roman 4 as an indirect co-perpetrator under Article 25 sub 3a against the health center in Sayo in the context of the first operation, and 4. Destroying the adversary property as a war crime under Article 8 sub 2e Roman 12 and as an indirect co-perpetrator under Article 25 sub 3a in Mongol and Sayo in the context of the first operation, and in Lipri, Tsili, Kobu, Jichu, Buli, and Sanji in the context of the second operation. Now, Mr. Ntaganda, please rise. Mr. Ntaganda, please rise. Mr. Ntaganda, for the reasons I have just summarized, the Chamber, having heard all of the evidence presented by the parties, finds you, as concerns count 1, guilty of murder as crime against humanity, as concerns count 2, guilty of murder as a war crime, as concerns count 3, guilty of intentionally directing attacks against civilians as a war crime, as concerns count 4, guilty of rape as a crime against humanity, as concerns counts 5 and 6, guilty of rape as a war crime, as concerns count 7, guilty of sexual slavery as a crime against humanity, as concerns counts 8 and 9, guilty of sexual slavery as a war crime, as concerns count 10, guilty of persecution as a crime against humanity, as concerns count 11, guilty of pillage as a war crime, as concerns count 12, guilty of forcible transfer of population as a crime against humanity, as concerns count 13, guilty of ordering the displacement of the civilian population as a war crime, as concerns counts 14, 15, and 16, guilty of conscripting and enlisting children under the age of 15 years into an armed group and using them to participate actively in hostilities, as concerns count 17, guilty of intentionally directing attacks against protected objects as a war crime, and finally, as concerns count 18, guilty of destroying the adversary's property as a war crime. Mr. Ntaganda, now you may sit down. Mr. Ntaganda is waiting for complete translation, it's fine. Mr. Ntaganda, as a result of the Chamber's judgment, you shall remain in detention until such time as the Chamber determined your sentence. And later today, the Chamber will issue an order instructing parties to file any request for bringing evidence in relation to sentencing. Based on these requests, if any, and in consultation with the parties, the Chamber will determine the timeline for submissions and hearing as soon as possible. The full judgment will be notified upon the closing of this hearing. Mr. Ntaganda, you are entitled to appeal this judgment within 30 days. Your defense team will be able to start discussing the judgment with you already today. As to the sentencing stage, the Chamber has considered which parts of the judgment you should be able to read yourself, and translation in Kinyarwanda of those parts will commence today. You will receive this translation as soon as it is ready. This concludes the hearing. I thank you, everyone. The court stands adjourned.
All rise. Veuillez vous lever.